about your behavior. Now, just because you loan Daryl your lawnmower and Daryl is now no longer around, you still can't go to the garage and pull the lawnmower out without some kind of legal authority to do it. So it can be very serious. It's rare, but there have been times when probate court judges have people been in jail, haven't there?
Yeah, I mean, yeah, because again, you can't. I was trying to make sure I'm answering any questions on Facebook.
Okay.
You can't, start exercising this will without permission.
That's right.
And here's the thing. There's a reason why I hate Google, and there's a reason why I hate these LegalZoom and all those other different things. Because LegalZoom or Google are not Tennessee specific.
That's true.
And in Tennessee, your will, I mean, there is some new, look, your mom or dad or whomever, or you can prepare a will and have the greatest intent. And because it misses one of those nuances, it will be invalid.
Absolutely correct. Absolutely correct.
And so,
and those specific nuances that you spoke about have to be included in the document in order for it to satisfy the requirements. So, in other words, you have to say that in the room at the same time, and I saw this person sign the document. So you can't create a document and then take it somewhere for somebody to sign later on. All of that will make that invalid.
And then it also, one of the things that happens is, and I've modified my attestation clause because there is a self-authenticating document that you got to have to the will. If you want to self-authenticate it, obviously people can come in and testify to what it says.
Right.
But if you want to self-authenticate it, the persons that are witnessing have to attest that they are above the age of 18.
That's right.
And of sound mind.
That's right.
Because that's required. And then that is attached to the sworn to and attached. And then that makes that a self-authenticating document.
Absolutely. And one thing about it, that is the last will and testament of the decedent. There's no correction.
Right.
If you don't get it right, you can't say, hey, meet me in the office next week.
Mom, come on by. Let's get
come by the office. Let's do it. Come by the office this afternoon and let's redo it. Because you got one chance and one chance only to get this document right.
Right.
And so, why take a chance on not having it right? Because you didn't want to consult with someone who has the knowledge to take care of it.
Yeah, I mean, and that's just, so then the judge basically, and people they have these tendencies to say, well, I don't want to do a will because I don't want the probate, court into my business. Yeah. If you don't do a will, they're definitely going to be in your business.
That's for sure.
And if you do a will, they're still going to be in your business because you want somebody to make sure Pookie going to do the right thing.
And so that's the reason why too. You don't have to share the contents of what's in there. All the attestation does is to certify that they saw you sign this document that purported to be your last will and testament. And that's why when you are preparing the instrument, you have a private conversation with the attorney. No one knows because of something called attorney-client privilege. We are bound not to disclose anything that was done in privilege. So no one would ever know unless you give permission for it to be revealed.
And again, some of the things that I do when I'm preparing these wills for people is, and I'm certain you do it too, and power attorneys, I do the same thing with power attorneys. When I initially assess that person, nobody else is in the room.
Absolutely.
It's just me and that person.
Absolutely.
Because, I know your son brought you down here. I know your daughter brought you down here, or your husband or your spouse or whatever. I don't really care.
That's right.
I mean, the reality is this is your will. And so I'm only caring about your wishes, and then I represent your interests.
That's right, because once you come into the office, then you become the client.
Right.
And no one else.
And no one else.
They can have the checkbook out in their hand. They can pay
I
in
take
cash.
I take their payments. I just can't represent them.
That's
you know?
exactly right.
And the law allows that. The law allows us to take clients' payments.
Sure.
I mean, the law actually. I mean, it had got weird at one point, right? That, and when what people used to do to go to different lawyers to disqualify them, so they could disqualify people from doing stuff. But the law has now evolved. I'm talking about the rules of professional responsibility.
Okay.
They have evolved. 1.18 talks about duty to prospective clients. So if it's a prospective client, if you didn't obtain confidential information from them, they're not a client.
Oh, yeah.
Yeah,
Okay.
I mean, again,
If you just consulted
I
with them.
consulted with them,
Okay.
but there's nothing that I obtained from them
Okay.
that I could use against them.
Gotcha.
For instance, if somebody comes to you and say, "Hey, tell me what this document says," and I, explain that document,
Right.
I'm not obtaining any confidential
Right,
information.
right.
Especially if the document comes from, I don't know, the Register of Deeds office.
Right.
I mean, how is that confidential?
That's exactly right. Yeah.
Anybody can see it.
It's a matter of public record.
Public record.
That's right.
Or if there's a lawsuit, hey, they sued me. Can you tell me why they sued me? The lawsuit is public record.
Right.
I mean, me telling you that they're suing you for 1, 2, 3, 4, 5, it's not confidential.
That's right.
And so what ends up happening is, so if you pay me for somebody, you're not a prospective client. I didn't obtain confidential information from you. I, talked to this person.
Right.
Now, if, I take the confidential information from the person that wants me to do the will, I learn some information about you and all the other kids and all this other stuff, and then the will is done, and then you want to hire me to contest the will.
Oh my God.
Contest the will.
Right.
Because you say, I know what your mother wanted.
Right.
And so because I know what your mother wanted, I could be a witness or all this other stuff. I really can't.
That's exactly right.
Again, and then that's a document that I'm prepared. Now, I guess I could testify to what it is that they wanted, in the event that there's an issue. But again, there are some rules out there. A lawyer shouldn't be a witness in a case that he is representing somebody on.
Right.
Unless you have another lawyer that's also on the case, because it kind of looks kind of weird. So I mean, there is some real nuances here, but the whole point of that matter is, just because they pay for the will or pay for the power of attorney, you have no duty and no responsibility.
Absolutely correct.
So when that person comes in the office and they say, well, can my son come in? I say no.
Well, I do something very similar to that, because I think many times people who do come in for that service are kind of frail and maybe a little infirm somewhat. Mm-hmm. So we have to develop a rapport with that person, and then we can let them know that we're just going to be stepping down to the conference room or something. Mm-hmm. And so, because we're required to let that person have strict confidentiality about what they're sharing.
Right.
Because we know that that the moms and dads don't want to say something in front of the children that might cause them an issue when they leave. I'm the one taking care of her. She living in my house. That mother, the one she giving, ain't never done nothing for her.
Right.
That kind of stuff. So to avoid that, we give them strict confidentiality and put them in a safe environment so they can freely express what it is that they want. And sometimes we have to even encourage them. Now, I really don't want to do nothing because I love all my children the same. And Mama, we know that. But like you say, Pookie ain't gonna do it right.
Pookie ain't gonna do it right. He ain't done right all his life, so he definitely ain't gonna do right.
He ain't gonna do right.
So we got a question, Jerome.
Okay,
and
sure.
this is a really, really good question.
Okay.
It says my mother's deceased, and she died about 1.5 years ago.
Okay.
So we know where we're
So
going.
no time frame. We know it's the mother. Okay.
Yeah. The hospital has asked for $650 from her estate. The estate has been distributed. Can I just ignore it? What do you think about it?
Wait a minute. So, why is the hospital entitled to the $650?
Okay, there you go.
Did they file a claim?
So
in the state?
Jerome hit this on the head. So let's walk through that. So if an estate has to be opened within I'm sorry, I take that back. A claim against an estate has to be filed within 1 year of the estate.
Yeah. I think it's even shorter than that nowadays. It's like 90 days.
No. I'm talking about I'm talking about, if you got a debt, all debtors got to come forward with and if you a debtor can open an estate for you.
Oh, sure.
Yeah,
sure.
so a debtor can open an estate.
Well, a creditor.
A creditor
can open an estate because a debtor is an individual who's being sued.
Yeah, a creditor, you know those terms.
Right.
A creditor can open an estate.
That's right. That's right. If you owe them money, yes.
And then try to get their money.
That's right.
And then once they do that, they can also file a claim.
That's
because
right.
in order to get money from the estate, you have to file a claim.
That's right.
Then once you file a claim, the person will receive notice from the probate court that somebody has filed a claim against the estate, and then they have a certain amount of time to object to that claim.
Yes, that's exactly right.
And so then if you don't object to that claim in a timely manner, there's an argument that you will owe that debt.
Well, you waived it. You
waived it.
And it's deemed to be owed. I mean, so that's an issue.
So so in this particular case, can I just ignore it? The real question here is, did this person file a claim within that year's time?
And there, I'm always concerned when people ignore legal process. Never, ever.
I don't think just ignore it is the right answer. So
ever is that
I'm not
the
going
right
to say
answer.
just ignore it.
Yeah.
But look, let's walk through that.
That's right.
Can they collect this $650 debt? I think the short answer to that question is no.
Yeah.
However,
It depends.
no, I think it's no, Jerome.
Okay, you think so? Just straight out no.
I really do.
Okay.
And here's the reason why. I'm sorry. I think it's no based off of these facts.
Okay, got you.
Because they say that the hospital asked for money a year and a half after she died.
Okay.
So that's over a year. A claim has to be requested for within a year of the death, or within 90 days of you filing. That's the one you were talking about.
There, I see all kinds of problems, and the reason why I see problems is there's nothing to indicate that the hospital was aware that she died. Because
that's not required.
Well, somebody's got to. You got to send notices out. You got to put a notice.
I don't have to. Okay, so here's the thing. I only have to send notices if I open the estate in less than a year.
Oh, I got.
If I open the
I got
estate
you.
in 1 year and 1 day,
I
I'm
got
not
you.
required to send
I got
any
you.
notice.
I got you. Okay, I got you.
And my notice can be simple. Is by publication.
That's what I mean.
Yeah. I mean, I don't have to.
In the Daily News.
Yeah, and anybody that open a estate in Shelby County, that's going to happen.
Yeah, publication. Okay.
Publication is going to happen.
Right.
So if they originally opened the estate, now I'm hoping that this person says, they've opened an estate to start this process.
Right.
At some point, whether it's a year and a half later or whatever. Because if you've distributed from an estate without an estate being open, I think you may have some problems.
Well,
Because what authorized you to do that?
Well, for one good thing though, there. So I like this. I like this because there are several types of estates that can be open.
Yeah.
You can do a small estate, and it's up to $50,000.
Up to $50,000.
If your
And there's no notice required.
distribution, it's really not, unless it's a known creditor.
A known creditor.
So you can open up a small estate. You can walk in there at 9 o'clock in the morning, be out by noon, and you'll have a small estate open.
Be out in 10 minutes. You be out sooner than that.
Well, I was just trying to give them a little time to sit on the little tables and chairs out there. Yeah, you're right. And so you'll be done. But you might have to put a bond up.
You
might have to.
When it's a smaller,
it depends on.
It depends.
Yeah.
It will depend, because normally you're still going to have to put up a bond on that particular matter. And again, some key facts here that jumped out at me.
Right.
Is the 1.5 years.
That's right.
And you know, and the second one that jumped out at me is that the estate has been distributed. You know, and then the third fact that jumped out at me: can I ignore?
Oh, okay.
Okay. The first one out of all these facts that the most troubling to me is can I ignore?
That's and I agree. That's the
Yeah.
one I would focus in on too.
You cannot
never ever close your eyes to a legal document.
Yeah, but the question becomes, how did they put you on notice? If they send you a bill to your house a year and a half later, I think you can ignore that. Because that's not the proper process, Jerome. Because the proper process is to file a claim on the estate. And then the probate court will send you notice. You can't get a judgment on me. I'm not the person. So if you send me a bill about my mother's death and it's been a year and a half after she dies, you just send me a bill, I am probably going to ignore that.
Well, and the other thing there is that you have no obligation to pay.
I have no obligation.
Your mother's
I don't have no
bill.
obligation to pay my mother's debt.
Unless now a lot of times too, and I'm glad we talked about it too there, be very, very careful. Sometimes if you take a person to the hospital and on the admission papers, you mess around and sign your name on there as being responsible.
Yeah.
Now that could create an issue.
It can.
But otherwise, there's no obligation for you to pay your mother's hospital bill.
I don't think so either.
Yeah.
Yeah. So if they send me a bill, I think you can ignore it.
Right.
But if they send you something from probate court saying that so and so filed a claim against the estate that's still open, now you got to do something.
I think so too.
Yeah, you got to do something, even if that's a late file on the estate.
But there are sometimes I don't know what you think. Tell me what you think about it. Sometimes I tell people to take and send a copy of their death certificate back in the envelope to show that that person is deceased.
Yeah, I think that's not a bad idea.
And I think that should put it to bed, put it to bed, because there's no obligation for you to pay the debts. Now, I don't know if it's changed or not. There, you can tell me. There is an obligation for a spouse to be responsible for medical debts of another spouse.
I don't know that rule.
If they changed,
Oh yeah, I don't know that.
Oh yeah. A spouse is responsible for the debts of another spouse. I mean hospital bills.
I don't think so.
I think it is there, unless it's changed. That's why I asked you.
No, I don't know anything about that.
Okay.
Because I tell spouses all the time, ignore it.
We'll look that up when we go.
I will look it up because I mean I've been thinking I've been right.
No, you're not.
But because the thing about this, it's not my debt.
Yeah, but a spouse is responsible.
Dude, hold up, Jerome. You know, now you and I are both black.
Right.
How many people you know that's black that been married 25 years and ain't lived with their spouse for 25 years?
Oh, well, that's a different story.
No, come on, man.
That's a different story. If you're not living. I mean,
the law don't care about that because according to what you're saying, a spouse is responsible.
And it may spread that far, but I don't see somebody coming after another person for a debt that when they've not been together for years and years and years.
How they know?
But I believe you probably can look it up, Barry. You got the fast machine.
Okay. Now I'm gonna do it now because I really want to.
I think because we see it all the time in automobile accidents. That the spouse is responsible for the debts of another hospital bill.
No.
I don't mean debts. I take that back, audience. But for medical care, I think it's still a fact.
I don't.
Okay.
Because now when you talk my language, you said automobile accidents. Because now
definitely not that.
Definitely not that.
Yeah, but medical care, I think so.
Yeah, definitely.
We'll look it up when we go off the show. What is this left?
Second question is: my mother died in 2019. My stepdad and her were married when they bought few properties. He said I have no right to any of it. Is that true? I'm in Tennessee. Absolutely.
Wait a minute. Say the facts again.
So his mother died in 2019. I don't think that's a red herring. That don't mean anything.
Okay, that's right.
But my stepdad and her were married when they bought properties together.
So
and then he says, do I have any rights to those properties? And I think the answer is no.
I'll be a little careful with that one.
Well, let me tell you the reason why. Tennessee has a rule that says when a husband and wife, when a person that's married buys a piece of property, then their spouse is automatically, and my daughter always corrects me when I say these words, a joint tenants with the right of survivorship.
It's actually tenants by the entirety.
It's tenants by the entirety.
Yeah.
She corrects me every time.
It's tenants by the entirety.
But
let me just tell you,
Okay.
it's presumed to be tenants by the
Exactly.
entirety. But what keeps you from writing into the document that it's not? It's tenants in common.
Yeah,
Remember?
Yeah, the only way, I'm glad you said that.
Yeah.
There's only one way
Yeah.
that you can
Bypass
or break
Right.
that hold
That's right.
on tenants by the entirety.
Right.
And that is you have to have a document repudiating the tenants by the entirety.
That's exactly right.
And
that's
most people
why
don't know. They don't know.
Well, and that's why a lot of times when you see warranty deeds, it will say an unmarried person.
Exactly. Or married.
Or married person, because it's an indication that tenancy by the entirety has joined, has coupled on there.
Right.
But I can also, and because I know that I have children, you follow me? And I know that he or she has children too. I can very well protect my children by saying that we're purchasing this property as tenants in common.
Yeah, but most people aren't going to do that.
I mean,
most people don't even understand the tenancy. They don't understand.
Well, they can come and ask you and
Yeah,
say,
but-
look,
yeah, but-
I want to make sure that my kids don't wind up like this situation here.
Right.
Okay.
But most people don't understand it.
Okay.
Let's think about it from this perspective. How many people did you know, Jerome, the spouse, the husband or the wife will buy the property because the husband or the wife has bad credit? And they don't want to put their name on it. And it says, Jerome Payne,
True.
married individual.
True.
But it won't say his wife's name.
True.
And with that, when you buy it and it says Jerome Payne,
True.
married individual,
True.
your wife was already, she is by the entirety.
That's right.
The only thing different between her and in this scenario is she ain't responsible for the loan.
I agree. I agree.
Yeah, she doesn't have any financial responsibility.
I agree.
So again, when he asked this question, that automatically tells me he has no rights because, when mom and stepdad bought the property, 99% of society do not understand in Tennessee when you marry, it's tenants by the entirety.
And also, but tenants by the entirety, tenants in common, joint tenants with right of survivorship, or joint tenants with reserving a life estate.
Mm-hmm.
So all of those things are mixed in there too. So in other words, what we're suggesting to you, just because you buy a piece of property, you're sophisticated enough to do that, don't necessarily mean that you understand how the conveyances
No, they don't.
can be a trap.
And most people are not they don't understand it because, they all giddy about buying a piece of property.
Right.
Now finally I'm getting that first house,
Right.
I'm married, but my spouse credit is so bad, but we're gonna have somewhere to stay.
Right.
And then when y'all go your separate ways, you thinking that you paying the debt, you've been paying the debt, so they don't have no rights to the property. And then, lo and behold, you go talk to the divorce lawyer. You say, "Oh, no."
Well, both of you all are paying because I'm paying half the house note and he's paying half the house note.
Yeah, but the documents, the mortgage deed doesn't show that.
You and I would disagree about that.
No, the deed don't say that.
I know it, but if I pay half on it, I'm half owner.
Yeah, you have owner because the law says